Welcome to Module 2 of the Bringing Your Mediation Practice to Maryland series. This module will focus on the unique Maryland court rules and statutes that relate to mediation. This module contains information with multiple choice questions throughout the module. Learners are encouraged to open the links in the Module 2 learning resources to access the full language of the rules and statutes referenced in this module. This module, including this recording and all related materials, is copyrighted 2024 by the Center for Dispute Resolution at Maryland Carey Law, all rights reserved. For permission to copy, share, adopt, or display this recording or any portion, please contact CDRA. This presentation covers the content for Module 2, Maryland Court Rules and Statutes Relating to Mediation. At the end of this module, you will have an increased awareness of the court rules and statutes applicable to mediation in Maryland. You will recognize the context and conditions in which the rules and statutes apply, and you will demonstrate an understanding of the rules and statutes through correct responses to questions. As a reminder, the information contained in this module was developed in May of 2024. Individuals should always consult appropriate source materials for most accurate rules and statutes. As Module 1 explained, the Maryland government is divided into three branches: the legislature, which makes law, the executive, which administers and enforces law, and the judiciary, which interprets and applies the law to specific disputes. What is important to know for this module is that the branch of government involved determines whether something is a rule or statute and its applicability. For the purposes of this module, we will focus on two branches of government, the legislature and the judiciary. The legislature passes proposed bills, which, if approved by the Maryland General Assembly and assigned or allowed to pass by the governor, become statutes, which are often referred to as laws. Depending on the definitions and scope, the statutes may apply to anyone in Maryland. The judiciary can develop and adopt rules that apply to the courts. Through the Rules Committee process, the committee drafts court rules, and if approved by the Maryland Supreme Court, these become part of the Maryland Code. This is an important distinction, which we will explore throughout this module. There are a variety of rules which apply to mediators in Maryland. We will start this module by exploring rules developed by the judiciary. The Maryland Court Rules devote an entire title, Title 17, to alternative dispute resolution. This module will provide a comprehensive review of this rule, as well as other rules which apply to mediation. Title 17 is a broad rule which applies to alternative dispute resolution and its various processes. As of 2024, Title 17 is comprised of 6 chapters. Chapter 100, Sections 17-101 through 106, cover the general provisions of alternative dispute resolution. This includes definitions, applicability, confidentiality, and most recently, remote electronic participation. Chapter 2, Sections 201 through 208 address provisions associated with proceedings in the circuit courts. Chapter 300, Sections 17-301 through 305 detail sections related to proceedings in the District Court of Maryland. Chapter 400, Sections 401 through 406 cover proceedings in the Maryland Appellate Court. Chapter 500, Sections 501 through 507 address collaborative law processes. This is separate from mediation and will not be covered in this module. Chapter 600, Sections 601 through 605 detail sections associated with proceedings in the orphans' courts. We will now take time to go through some of the most relevant chapters in detail. For the purposes of this module, we will focus on the chapters and information related to mediation. When determining applicability, simply put, the court rules apply when matters are before the court. If the court is not involved in a matter, then it has no authority, and thus the court rules do not apply. 17-101 covers general applicability. The specific language of this section is bolded to emphasize that Title 17 only applies when the court refers the matter and the matter is civil in nature. This is reinforced by the committee note, which indicates that this title does not apply to an ADR process in which the parties participate without a court order of referral to that process. In other words, if there is a matter before the court and the parties decide to use mediation, and the court or an office of the court is not involved in the referral to mediation, then Title 17 does not apply. Also, Title 17 does not apply if the matter is criminal in nature. We will learn later what statutes or rules do apply in these circumstances, but for now, we will focus on Title 17. Many rules have exceptions, and 17-101 has 4 specific applicability exceptions. First, if the action or order involves the enforcement of a contract to use ADR, then Title 17 does not apply. The court rules of Title 17 also are not appropriate when the matter is before other dispute resolution processes or tribunals, such as foreclosure mediation, healthcare ADR, or specific domestic matters. We have come to our first quick question, applicability. In which situations would Title 17 apply? A, the parties mediate a contract dispute from a court order to mediation before the trial date. B, parties decide on their own to hire a mediator for their contract dispute before the trial date. C, parties engage in mediation for a misdemeanor assault charge after the state's attorney's office identifies the matter as appropriate for mediation. And D, parties agree to mediate a landlord-tenant dispute in the district court on the day of trial through the district court ADR office. Quick question number 1 answers. If you haven't determined your own answer to this question, please pause the video now and make sure you have your answer before proceeding. The question is, in which situations would Title 17 apply? Let's look at these one at a time. For Title 17 to apply, certain conditions must exist. There must be a court referral, must be a civil action, and the matter must not involve certain listed exceptions, which mostly involve authority of other entities. A. The answer is yes, Title 17 applies. In situation A, the court ordered the case to mediation, so a court referral exists, and it's a contract dispute, so it is a civil action. Title 17 applies. For B, Title 17 would not apply. In situation B, the parties are hiring their own mediator, so even though it is a civil matter, the court is not involved in the referral to mediation, so Title 17 does not apply. In C, the answer is also no. In situation C, the case involves a misdemeanor assault, which is a criminal matter and not a civil matter. This falls beyond the applicability of Title 17. And finally, D, yes, Title 17 applies. In situation D, the parties agree to mediate, and it is through the district court ADR office, so the matter was formally referred to mediation and the court is involved. The case is landlord-tenant, so it is civil, and Title 17 applies. Good job on completing your first quick question. We now move on to 17, Chapter 102. Chapter 102 defines 12 different terms. We will highlight the terms most relevant to mediation. Please take some time to read through these 3 definitions of ADR organization, ADR practitioner, and alternative dispute resolution. It's worth noting that in Maryland, the definition of ADR organization largely applies to community mediation centers and law clinics. For ADR practitioner, a mediator would be considered an ADR practitioner. Please go ahead and pause this video so you can read through the 3 definitions. Once you're finished, you may resume with the video. We will continue with 2 additional important definitions from 17-102, mediation and mediation communication. Mediation has a specific definition in the Maryland courts. Mediation means a process in which the parties work with one or more impartial mediators who, without providing legal advice, assist the parties in reaching their own voluntary agreement for the resolution of all or part of a dispute. On this slide, the italics emphasis has been added. The definition of mediation communication is important as it relates to mediation confidentiality. The definition of mediation communication is expansive to cover all parts of the mediation process, from helping parties consider mediation through post-mediation evaluation. The definition includes spoken, written, and nonverbal communication. It is important to note that although Title 17 references other ADR processes, it only defines mediation communication and not communication associated with other ADR processes. We now come to quick question number 2, mediation communication. Which of the following is a mediation communication? A, statements made during a mediation joint session. B, phone call with the mediator to determine if the matter is appropriate for mediation. C, copy of a lease shared with the mediator. D, reasons for declining a mediation shared with the mediator during intake. And E, all of the above. Please pause the video and determine your own answer to this question. The correct answer is E. Everything listed was a spoken, written, or nonverbal communication. Everything was made as part of a mediation and falls within the time frame of considering, initiating, continuing, reconvening, or evaluating. Whether any of these is confidential or an exception to confidentiality is something we will review later in this module. But at this point, they all fall under the definition of a mediation communication. Title 17-103 defines the role of the mediator. This definition of the role of the mediator may be similar or different from the mediator roles emphasized in your basic mediation training. Specifically, the end of Chapter 103 emphasizes that while acting as a mediator, the mediator does not engage in any other ADR process and does not recommend the terms of an agreement. This rule has a relevant committee note regarding the role of the mediator and the agreement. The note states, the mediators often record points of agreement expressed and adopted by the parties to provide documentation of the results of the mediation. Because a mediator who is not a Maryland attorney is not authorized to practice law in Maryland, and a mediator who is a Maryland lawyer ordinarily would not be authorized to provide legal advice or services to parties in conflict, a mediator should not be authoring agreements regarding matters in litigation for the parties to sign. If the parties are represented by counsel, the mediator should advise them not to sign the document embodying the points of agreement until they've consulted their attorneys. If the parties, whether represented or not, choose to sign the document, a statement should be added that the points of agreement, as recorded by the mediator, constitute the points of agreement expressed and adopted by the parties. We now move on to mediation confidentiality, Title 17, Chapter 105. Title 17 addresses confidentiality of mediation among its general provisions. The levels of confidentiality differ for the mediator and the parties. As we begin the review of this topic, it is helpful to note that Maryland has adopted very strict protections for the confidentiality of mediation communication as they apply to the mediator. Keeping this in mind as we explore this section will assist you in the later application of confidentiality to various scenarios. We are now at quick question number 3, confidentiality. Is it accurate for the mediator to make the following statement? Mediation is a confidential process. Everything stated in this mediation is confidential. Think to yourself how you would answer this question. Is this a statement that you include in your mediator opening statement? The answer to this is no. In Maryland, this statement is both inaccurate and misleading. As we are about to review, there are exceptions to confidentiality and different confidentiality requirements for the mediator and the parties. We will start with the rule and confidentiality as it relates to the mediator. The rule states that except as provided in Section C and D of this rule, a mediator and any person present or otherwise participating in the mediation at the request of the mediator shall maintain the confidentiality of all mediation communications and may not disclose or be compelled to disclose mediation communications in any judicial, administrative, or other proceeding. We want to highlight a few things about this definition. First is that it applies to the mediator and any person present or otherwise participating at the request of the mediator. This may be some confusing language, but really what it means is a co-mediator, an observer, a program manager, someone like that. Another point is that the rule uses very restrictive language such as shall and all or may not. The mediator shall maintain the confidentiality. The confidentiality of the mediator cannot be waived. Therefore, under this language, the mediator is prohibited from disclosing mediation communication, even if the parties all agree that it would be okay. Finally, the language emphasizes that not only can the mediator not disclose, the mediator cannot be compelled to disclose. This language is designed to protect the mediator against subpoenas or other requests by parties or the court to disclose protected mediation communication. We will now look at confidentiality as it pertains to the parties in a mediation. The party obligation to maintain confidentiality is much more permissive. A party to a mediation and any person present or who otherwise participates in a mediation at the request of a party may not disclose or be compelled to disclose a mediation communication in any judicial, administrative, or other proceeding. In this section, we also see a reference to any person present who participates at the request of a party. Here, the phrase likely refers to someone like an advocate, a support person, spouse, property manager, someone like that. Part B1 limits the disclosure of mediation communication in a judicial, administrative, or other proceeding. This mirrors other court rules applying confidentiality to negotiation-based conversations in the interest of promoting candor and resolution. This also means that any party or person who participates at the request of the party can disclose mediation communication anywhere else that is not a judicial, administrative, or other proceeding. Part 2 allows the parties to determine their own higher level of confidentiality if they want to. They just need to do it through a formal written agreement. Maryland, like other jurisdictions, has exceptions to confidentiality in mediation. Section 17-105 lists the various exceptions to confidentiality. Many mediators provide the exact language from the rule in their agreement to mediate. This is not only to make sure that the mediator has provided the correct information, but also because the ethical standards require the mediator to review confidentiality and its exceptions with the mediation participants. In Maryland, a standard exception to confidentiality is the agreement reached in mediation. Parties that wish to have the mediation settlement agreement confidential will need to put their confidentiality requirements in writing. Permitted disclosures include prevention of serious bodily harm or death, defense against mediator misconduct or actions, and challenges to the mediation agreement. There are other laws which may apply to the mediator that provide for an exception to confidentiality. If they apply, the mediator has an obligation to inform the parties. These may include mandatory reporting requirements, such as those for child or vulnerable adult abuse. Some mediators may have other mandatory or permitted reporting requirements, which should be clearly articulated at the beginning of the mediation. It is also important to note that mediation communications that are confidential under this rule are not subject to discovery, but information that is otherwise admissible or subject to discovery does not become inadmissible or protected from disclosure solely by reason of its use in mediation. You should take some time to read through the permitted and required disclosures and make sure that you are aware of them and any mandatory reporting requirements that may apply to you while you're mediating in Maryland. We are now at quick question number 4, confidentiality. In a moment, you'll hear a scenario with 2 questions. After reading through these questions, hit pause and take some time to answer the questions yourself. When you're ready, advance to the next slide to get the responses and an explanation. Here's the scenario. The parties participate in mediation for a negligence claim with an $80,000 amount in controversy. The mediation is a result of a court order to mediate for 4 hours. At the end of the 4 hours, the parties have made progress on 2 of the 4 terms, but no final agreement is reached. The defendant declines to continue the mediation or reconvene at another time. The mediator submits the mediation outcome form to the court indicating mediation, no agreement. A. You receive a call from the court asking if the parties were close to settling and why it didn't settle. What information can you share with the court? B. The parties appear for the scheduling conference and are asked why they didn't settle in mediation. What information can the parties share? Hit pause to formulate your own answers to these questions. Again, when you're ready, advance to the next slide to get the responses and an explanation. Quick question number 4, confidentiality answers. You receive a call from the court asking if the parties were close to settling and why it didn't settle. What information can you share? That mediation occurred and no agreement. Basically the same information you already told the court. Under the confidentiality provisions, the mediator cannot share the details of what was discussed in mediation. This includes details of how close to settling and why no settlement was reached. For B, we're asking what information can the parties share? Mediation occurred and no agreement, basically the same thing. If the parties' communication with the judge is part of a judicial proceeding, then they too cannot share the mediation communication. The question came about during a scheduling conference, which is part of a court proceeding. Outside of court proceedings, the parties could share more information. The mediator still cannot share additional information. Title 17, Chapter 106, Remote Electronic Participation, is the most recent section added to Title 17 in 2023. This rule gives the mediator authority and guidance to determine the appropriate format for the mediation process. 17-106 provides a definition and general provisions for remote electronic participation. Here, remote electronic participation includes alternative dispute resolution taking place when the participants are not all in the same physical location. Any or all parts of the process may involve remote electronic participation. The court gives the mediator, in consultation with the parties, the authority to determine the format of participation and provides factors for making this decision. These factors include accessibility, technology competency of the neutral, confidentiality, and party preference. A final factor for consideration is the impact of the format on the fairness of the proceeding. Title 17 of the Maryland Court Rules is very comprehensive, as we have already learned. However, there are a few other rules which are relevant if you want to bring your mediation practice to Maryland. We now turn to Title 9, Section 205. This rule addresses mediation of child custody and visitation disputes in Maryland. It addresses topics such as definitions, duty of the court, mediator qualifications, court designation of the mediator, fees, and outcomes. Additional training and processes apply to the mediation of child custody and visitation disputes in Maryland. Rule 9-205 requires, for all child custody and visitation disputes, the court determine whether mediation is appropriate and the availability of a qualified mediator. It also details information such as whether mediation is appropriate where intimate partner violence, abuse, or coercive control is involved, and what the mediator may tell the court. Details about this rule and other aspects of mediation of child and custody visitation disputes is covered through a Maryland-focused 20-hour child access mediation training. Another relevant court rule is Title II of the Maryland Court Rules. This rule covers limited scope representation. Limited scope representation allows an attorney to form an attorney-client relationship for a specific and limited purpose. Maryland rules permit limited scope representation in several contexts, including representation in a court-ordered mediation. The Maryland Rules of Civil Procedure, Chapter 100, Commencement of Action and Process, contains subsections for limited scope representation in the circuit and district courts. We will now move away from the judicial branch of government and the court rules and cover statutes passed by the legislative branch. Mediation in Maryland has statutory protections for confidentiality as established through the Maryland Mediation Confidentiality Act, or Section 3-1801 of the Maryland Annotated Code, Maryland Courts and Judicial Proceedings. Passed in 2012, the Maryland Mediation Confidentiality Act was a collaborative effort of the various Maryland-based mediator practitioner organizations, the Center for Dispute Resolution at Maryland Carey Law, and the Maryland Judiciary to codify confidentiality protections for non-court connected mediation. The Act aims to mirror the confidentiality protections established in Maryland rules. It is important to note that knowledge of the Maryland Mediation Confidentiality Act is not a requirement for court-approved mediators. However, because most mediators engage in mediation both through the court and outside of the court, it is important to understand its various provisions and applicability. Applicability of the Maryland Mediation Confidentiality Act. The Maryland Mediation Confidentiality Act applies when 1. Parties are required to mediate by law, 2. Parties are referred by an administrative agency or arbitrator, or 3. The mediator states in writing that confidentiality applies to any and all parties to the mediation and persons with whom the mediator has engaged in mediation communications, that the mediation communications will remain confidential in accordance with this subtitle, and 2. The mediator has read and, consistent with state law, will abide by the Maryland Standards of Conduct for Mediators during the mediation. Since subsection 3 requires the mediator to state in writing that confidentiality applies, a best practice is to include this language in an agreement to mediate. It also means that failure to include this language will mean that the Act does not apply and no statutory protection to confidentiality in mediation will exist. In addition to the requirement to invoke confidentiality through specific statements, the Maryland Mediation Confidentiality Act will not apply in other circumstances as well. Most notably, if Title 17 applies, the Maryland Court Rules, then the Mediation Confidentiality Act does not apply. Please take a moment to read through the other instances when the Confidentiality Act does not apply. Press pause if you need to, and then advance to the next slide. Quick question number 6, Maryland Mediation Confidentiality Act. In this, both the questions and the answers will be revealed on the same slide. You will need to hit pause to determine your own answer, and then hit play again to reveal the correct answer and explanation. For each of the following examples, indicate whether Title 17 or the Maryland Mediation Confidentiality Act would apply. A. A mediator on the Frederick County Circuit Court approved roster receives a notice from the court to mediate a case. Pause to determine your own answer. The answer is Title 17. Title 17 applies because it was the court who provided the notice to you as the approved roster mediator. The court referred all or part of the civil matter to ADR. Therefore, the court rules would apply. B. A mediator who is hired by the parties to mediate a matter that is in the Frederick County Circuit Court. Pause to determine your own answer of whether the Title 17 or the Mediation Confidentiality Act would apply. Here, it is the Maryland Mediation Confidentiality Act. The parties hired you to mediate the matter, and the court is not involved, so Title 17 does not apply. In this instance, the mediator would need to invoke the Maryland Mediation Confidentiality Act by indicating that the mediation is confidential and that the mediator agrees to abide by the Maryland Standard of Conduct for Mediators. We continue with some of the details of the Maryland Mediation Confidentiality Act. Just as in Title 17, there are exceptions to confidentiality included with the Maryland Mediation Confidentiality Act. In all instances, the party and the mediator may agree to reduce the confidentiality protections by agreeing to exclude all or part of the mediation communication from the Act. In this instance, a best practice is to put this in writing with the signature by all parties and the mediator. The Maryland Mediation Confidentiality Act largely mirrors the language of Title 17, 105 in its scope and exceptions. Since we reviewed Title 17 rules for confidentiality and exceptions in detail, we dedicate this portion of the module to highlighting where the Maryland Mediation Confidentiality Act differs from the court rules. The differences listed in this slide specifically aim to shield the mediator from involvement in a judicial proceeding arising out of what occurred in the mediation. The mediator and the parties may assert or defend against allegations of professional misconduct or malpractice by a party or person, except that the mediator may not be compelled to participate in a proceeding arising out of the disclosure. Also, a court may order mediation communications to be disclosed only to the extent that the court determines the disclosure is necessary to prevent an injustice or harm the public interest that is of significant magnitude in the particular case to outweigh the integrity of the mediation proceedings. Congratulations, you're almost at the end of Module 2. This module detailed a lot of specific information. Let's take a moment to review what was covered. In this module, we reviewed the court rules, statutes, and regulations that apply to mediation in Maryland. The module emphasized the applicability of each of the rules and statutes and the need for the mediator to evaluate the circumstances to determine what applies. The module highlighted Maryland's broad definition of mediation communications and its strict confidentiality requirements for the mediator and limited confidentiality requirements for the parties. You are now aware of the general provisions of Title 17, Chapter 100. You will need to review the subsequent chapters to review different information for mediation at the various court levels.